Good day, Doctor. We are from Group 6. Today, we are going to discuss on Topic 1, which is the rights and liabilities of hirers when default of payment and repossession by the owner. My name is Ho Kai Man, metric number 279215.
My name is Lin Hui Wen, metric number 279005.
Hi, my name is Nurdina binti Samsul, and my metric number is 280064.
Hi, I'm Tashinda Khan, a perempuan Jaspersin, and my matrix number is 281636.
Greetings, Dr. Asfalila. My name is Farhana binti Shamsuri.
To introduce our topic, Malaysia originally does not have any legal scripture regarding hire purchase and very depending on common law in order to solve the problem that arises due to hire purchase. But after the redevelopment of law, Malaysia now has its own legal scripture that was called as Hire Purchase Act 1967. So under the Section 2 of this Act, hire purchase transaction was defined as transaction of hire with an option to purchase the goods regardless of whether inside of the agreement the installments was defined as hire or rent or otherwise. While the definition of hire purchase based on legal scholar, hire purchase can be defined as an agreement where the owner gives the hirer the rights to obtain the goods, whether through purchase or through rent. The scope of hire purchase was covered inside the item 1 of first schedule, where all consumer goods can be put into hire purchase. This Hire Purchase Act also governing on the scope of statutory rights of the hirer and the rights of the owner to repossess the goods.
They're explaining about rights and liabilities of hirers when default of payment and also repossession by the owner. Principally, hire rights are outlined in Sections 19 until 15 of the Hire Purchase Act 1967. Firstly, Section 9 emphasizes the supply of documents and information, and there is an exception to this proviso. Section 9(2) provides that the owner must comply with a request made within 14 days and is subjected to a fine up to 1,000 ringgit if found guilty as demonstrated under Section 9(3). Moving on, Section 10 stipulates the appropriation of payments, while Section 11 is implemented in the case where the power of the court is required to allow goods to be removed. For this case, a hirer can apply to the magistrate court. Next, issues relating to rights assignment can be found in Section 12, and Section 12(1) until subsection 4 are also included. When the hirer passes away or becomes bankrupt, Section 13 may be implied. Meanwhile, Section 14(1) until subsection 4 explains concerning the early completion of the agreement. Lastly, Section 15 highlights the issue of the termination of the hire purchase agreement.
The first case is Leong Wan Chun and Consolidated Leasing, M in bracket, Sinin Berhad, 1998. In this case, the plaintiff led to the first defendant, who is Interpol Travel and Tours Agency, a luxury air-conditioned bus. However, the first defendant had failed to pay the monthly rentals and causing the appellant in this case to guarantee all sums of money due by the first defendant to the plaintiff. The plaintiff brought this matter to the court with argument saying that the payment, saying that due to the defendant who had failed to pay the monthly rentals, the agreement has been terminated. So, and the judgment was made on behalf of the plaintiff, and the appellant in this case appealed to the Court of Appeal. Held, the court declared that the contract was still subsisting since the plaintiff itself did not elect the contract has been terminated, and also it cannot be done by the defendant to terminate the contract or the hire purchase agreement. And in the statement of claim itself, it does not stated that there is the liability for the hirer to guarantee or make.
Under rights and liabilities, we have included two cases, which is the case of Leong Wan Chun against Consolidated Leasing, Sendirian Berhad, and also United Engineers Malaysia against Life in You. The section applied under this case is Section 15, subsection 1 of the Hire Purchase Act 1967. This section is applied as it gives the authority to the plaintiff and defendant to terminate this agreement if one of the parties in this contract does not fulfill the requirements in the agreement. Apart from that, in this case, the defendant did not fulfill their promise, which is they did not pay the monthly installment, which led the plaintiff to grant for repossession. Looking up upon this, the court came to a conclusion that the plaintiff has all the rights and authority to terminate this agreement and further make their decision on the behalf of the plaintiff.
To the repossession by the owner, the statute for this is laid down under Section 16 of the Hire Purchase Act 1967, Section 16.1, which explains when the owner can repossess the goods, while Section 1C tells us in the event where a hire is deceased. Next, Section 16.2 clarifies how will the owner be excused from complying with, while Section 16.3 provides the period of when the owner is required to serve the notice. Also, Section 16.4 describes that a document of description must be set out. Lastly, Section 16.6 justifies what will happen if the owner fails to serve the notice, while subsection 6a enlightens the issue of the cost of repossession, the cost incidental to repossession, and also the storage cost. That is all from me. Thank you.
Moving on to the next case is the case of Pang Brothers Motors Union Berhad and Lee Akseng 1978. In this case, a car was repossessed by the appellant since the respondent did not comply with the notice issued to him under Section 16, subsection 1 of the Hire Purchase Act. And consequently, the respondent filed a writ against the appellant by claiming that the repossession of the car was illegal. The court dismissed the appeal since there is a doubt as to whether the notice issued by the appellant to the respondent was in fact served, and the court also declared that the repossession of the car was illegal under Section 16 subsection 1, since in this case to apply Section 16 subsection 1 of the Hire Purchase Act was in fact in law. So therefore the repossession of the car by the appellant was illegal, and the court requests the car to be returned back to the respondent. That's all from me. Thank you.
Analyzing the cases under repossession by owner, we have included the case of Pang Brothers Motors Sendirian Berhad against Lee Akseng and United Manufacture against Sulaiman bin Ahmad and another. The law which is applied under these both cases is Section 16 subsection 1 and Section 16 subsection 3 of the Hire Purchase Act 1967. The court applied this section because the plaintiff or defendant under these both cases has all the authority to repossess the goods. Meanwhile, Section 16 subsection 3 has been applied in this case because after repossession, the plaintiff, which is the owner, needs to serve on the defendant within 21 days as set out in the 5th schedule. Thus, looking into great depth of all the section applied, the court granted justice on the behalf of the plaintiff.
In conclusion, there are laws provided from Section 9 to Section 15 of the Hire Purchase Act which clearly stated the rights and liabilities of the hirers. According to these sections, they have relatively high freedom to require the owner to exercise their request on the goods. Besides, there are also rights given to the hirers to terminate the hire purchase agreement by returning the goods to the owner as provided by Section 15. When the hirers fail to make payment, they may also introduce a cash buyer to the owner at a price agreeable by the owner to purchase the goods. When a default of payment occurs, which means the hirer violates his responsibilities under the hire purchase contract, the owner can repossess the goods by giving a 21-day of intention of repossessing notice.
Next, I'm going to discuss regarding the repossession by the owner. The prevailing law on hire purchase in Malaysia has lasted for a period. Despite the ways of repossession that the owner can practice, there are still loopholes concerning implementation of this solution. Undeniably, the specifications of the Act looks kind of overprotective towards the hirers. In short, the hirer has to be prompt in his or her payment, or else he or she may possibly be obligated to the payment for the penalty fees. If, in any circumstances, the hirer deliberates that he or she is incompetent to remunerate the payment, a beneficial suggestion is to get in touch with the owner without any hesitation for a resolution. The proprietor tends to form a discrepancy in the gauge of rightness under hire purchase agreements. It is herewith endorsed that Section 16 Clause 6 of the Act has to be revised to eradicate the form of one-sidedness in the gauging of impartiality in advance of hire purchase dealings. Thank you, Doctor.